hi again, everyone. The GDPR has already been mentioned this afternoon. What I will speak about is a very specific part, not only of the GDPR, but thanks to some recent case law, also the consequences of a verdict of the European Court of Justice called the so-called Schrems II decision, plus some guidance that we have seen in the last years, which means that international data transfer really is subject not only to the GDPR itself, but also to this case law guidance, and all that brings up a mix of, fair to say, I believe, a huge part of legal uncertainty when it comes to international data transfers. To give you a very well-known example where this plays a role in practice is the transfer, for example, of HR data in a group of companies. So imagine there is a company with its parental entity in the US, and they have subsidiaries in Europe. They have a software as a service agreement with a company that provides them with an HR software, and then they give sub-licenses to their European entities, and the entities use the software in order to process and transfer HR data into their headquarters. That's a very typical scenario, and HR data is, by the way, one of the most important field of GDPR compliance, and that is a scenario where the requirements for international data transfers come into play. Another example that's probably more familiar with many of you is everything around international data transfer when it comes to clinical trials. Because if you are operating with European sites, of course, there will be transferred personal information, personal data, patient data, and health information as well on an international level, which means you're again in the middle of the requirements for such international data transfer under the GDPR. And the GDPR in its Chapter 5 knows quite a number of legal grounds that you can rely on when it comes to transfer of data outside the European Union. And what looks like quite a variety on this slide, if you take a closer look, there's not much left that you can rely on, because this one, the Privacy Shield, has been invalidated by the European Court of Justice like 2 years ago. That was the consequence of the so-called Schrems II decision. If you take a look at the second and the third and the fourth column, then I wouldn't say you can ignore these, but the so-called binding corporate rules are an important legal ground for huge international multinational companies. It's quite a complex project if you want to rely on these binding corporate rules, but for the majority of companies that are working in the context of international data transfer, what remains are the standard contractual clauses, and that's also what I will speak about in this presentation. So that is really one of the most important remaining legal grounds for international data transfer on all levels. Besides of that, you have, of course, the so-called adequacy decisions. The European Commission can, by an official approval, say that certain jurisdictions have the same level of data protection equivalent to the one in the European Union. There has been approvals for a number of countries. You see some examples here. So Argentina, Canada, Japan, and some others are officially approved as having the same level of data protection as the European Union. In that case, you don't have an issue. But with regard to data transfer between the European Union and the US, the standard contractual clauses play, I would say, the most important role. So let's have a very brief look at the consequences of the so-called Schrems II decision. The verdict was from July 2020, and it dealt with the requirements for international data transfer, particularly to the US, and more precisely, in particular, with the consequences of the US surveillance laws, and to what extent that would still guarantee or not a level of data protection that is similar to the one in the European Union. You will all know about the consequence of that verdict. First of all, the EU Privacy Shield was killed. That is what we have seen on the previous slide. So we are missing one very important legal ground for international data transfer for more than 2 years now. You will have seen in the news that there's light at the end of the tunnel. About a month ago, President Biden signed the so-called executive order for a new EU-US data privacy framework. I will speak about that later, but as for now, we only have the executive order, and it has not led yet to a new alternative solution that would replace the invalid privacy shield. There are still some steps to go on the side of the European Commission until that will enter into effect. So anyway, the important message from the Schrems II decision was that yes, the privacy shield was killed, but the standard contractual clauses can still be used. And already at the time of this verdict, the back then actual SCCs have been under revision, not only because anyone expected this verdict of the European Court of Justice, but also because the old set of standard contractual clauses they will still be tailored under the previous data protection framework in Europe, the Data Protection Directive, and they have not been adjusted to the requirements of the General Data Protection Regulation. So the Commission was working on a new set of standard contractual clauses anyway. This new set is in effect since June 2021. I will come to that on the next slide. But let me already give you one important message here. It's not just enough to rely on these standard contractual clauses, because one consequence of the European Court of Justice verdicts was that the consequence is that you also have to carry out a so-called transfer impact assessment. You cannot only rely on the SCCs, you have to assess the privacy framework in the country where you would transfer data to. And that is quite a challenging topic. We will come to that later as well. But the key message here already is it's not all about the standard contractual clauses alone. There's some additional homework that you need to do if you want to work with these standard contractual clauses. So very shortly after the verdict, we saw a lot of interesting responses from the regulator or reactions to this decision. First of all, the European Data Protection Board, which is the umbrella association of all European data protection authorities, provided recommendations, including how to produce such a transfer impact assessment that I mentioned, and what so-called supplementary measures might be, because the key idea of the transfer impact assessment is to assess whether you have an equivalent level of data protection or not. And if you come to the conclusion that this is not the case, then you're obliged to implement additional supplementary measures in order to protect the personal data that are transferred outside the European Union. I already mentioned the new SCCs. These have been released in June already, 2021. And also important to see that while everyone, was kind of unsure about the reactions of the authorities in terms of potential investigations, we have not seen serious enforcement action, at least not in the life science sector in a broader sense so far. The authorities in Europe are very much focusing on the huge online platform services. They are focusing on services like Microsoft and many other well-known services that also contain the transfer or exchange of personal data between European companies or customers and their US service providers. But the particular life science sector in a broader sense has not been subject to any investigations so far, which is actually good news at that point. So what's the difference if we look at the old SCCs and the new SCCs? The old set of SCCs has been not very flexible. There were only 3 different modules that you could make use of, 2 different kind of so-called controller to controller, standard contractual clauses, and 1 set of clauses for the use between controller and processor. Compared to that, we have a much more flexible approach with the new SCCs. We have 4 different modules. And depending on the roles of the parties that are exchanging data, you can pick the relevant modules, plus certain clauses that you will or will not use, and all that can be composed into one set that fits your individual needs for the specific data transfer between two or more entities. Two or more is a very important buzzword here. And what's also important is that the new set of SCCs contains a so-called docking clause, which makes it very easy, in particular in very complex chains of companies or companies that belong to a group of companies that you can add step by step to the SCCs. Now, that's very flexible as well, and one very important improvement in this new set of standard contractual clauses. So what's the supervisory authority views on the use of SCCs? First of all, there are some important deadlines that you need to take into account. The most important one is the second bullet point here, because the authorities expect companies that have entered into the new SCCs for existing DPAs before the 27th of December 2022, which is very close now. So very important for companies that might still rely on the old SCCs in some cases. Now it's the last weeks that are starting in order to adjust that and to change to the new SCCs. The 27th of December is the last deadline for that. And as I already mentioned, the new SCCs do not come alone or stand alone. They come with the additional obligation to create a transfer impact assessment. And we have also seen very important guidance, that was too fast, of the European Data Protection Board on how to carry out such a transfer impact assessment in detail. It's a step-by-step approach. We will come to that later. But let's go back to the slide. So what would you do in the scenario that I presented in the beginning of this presentation? You would add the relevant SCCs in this scenario between the different companies. You would, of course, need to individualize them, and that would be your way to secure the international data transfer for this example when it comes to the exchange in the context of HR data. It's a little bit unsecure with regard to clinical trials, because there are many different opinions on the relation between the sponsor and the site. It depends very much on the individual case, of course. I don't know if some of you have made these experiences already, but some sites even see themselves as a processor, and they would provide you with a completely different set of modules for the SCCs. Compared to sites that would say, no, we are both individual controllers. And others would say, and again, it depends on the individual case, we are joint controllers. We are jointly together determining the data processing that is relevant for a certain study. And that can end up in quite tricky situations, to my experience, because if a site insists on having a certain role, let's say they are insisting on being an individual processor, while you believe you're a joint controller together with the site, then at some point of time you will have to answer the question, what do I do? Do I try to convince them that they are following my position and we use a different set, or we maybe do not need any SCCs at all, or just for the sakeness of getting the clinical trial started, I just follow their position even if I believe, or my legal department or lawyers believe, that it's not a joint controllership, but it's a controller-to-controller relation. So that's sometimes very tricky. My advice always is to see it from a risk perspective. What would be the worst case if you would rely on not the right set of modules under the SCCs? I think in the majority of cases, this risk is very limited in terms of not only investigations, but also in terms of potential fines. I wouldn't say at the end of the day, it doesn't matter which module you use, but I think it's fair to say that one can use a very practical approach here and should not, well, end up into endless negotiations about what is the right scenario here. I think a practical approach is a very good advice in that scenario. So let's assume both parties agree that they are independent controllers, then you would use the module 1 of the SCCs in this case, and everything's fine so far, apart from the individual homework that you need to do in addition. What we did at Fieldfisher as a little gimmick, together with our legal tech team, we created a tool where you can automatically compose the right modules of SCCs that are relevant in the specific context and in the specific scenario. You just need to answer a couple of questions. It doesn't take 5 minutes, and that's at least a first step that can make it easier to find the right and compose the right modules for a specific case. But as I said, it's not only about the modules. You need to do some individual homework. So SCC sounds very easy from a first point of view. It's a standard, so that makes it very comfortable. But it's not all about standards. It's actually the opposite. You need to do a lot of individual work. You need to assess your data flows. As I said before in the example of a clinical trial, it's sometimes difficult to correctly define the role of the parties as controllers, joint controllers. Controllers are processors. All that has to be done. So such a tool can help, of course, but the information about data categories, the purpose, the individual and security measures, the technical and organizational measures that are in place to protect the data, all that needs to be assessed. And the SCCs need to be filled out accordingly. It's never just print out and add some like general information. If you want to do it at least a little bit proper, you will need to assess quite a lot of information regarding to that specific data flows. And then, as I said, the data transfer impact assessment plays a very important role. And we have guidance about that. Many of you will know that from the European Data Protection Board. That recommends a 5-step approach, actually. The first one is very obvious: know your transfer. Of course, the bigger the company and the more complex your relations in data transfer with other companies, you need to assess, of course, in which cases you have relevant data transfers at all. Then you need to identify the transfer tools you are relying on, and then step by step you come to the final version of your transfer impact assessment. And the last step is, of course, that you have to re-evaluate the TIA at appropriate intervals. That can be different from company to company, what is appropriate and what not. But at least the first 4 steps are important to take if you carry out such an TIA. Then also very interesting and important recommendations from the EDPB with regard to supplementary measures. What do you have to implement if you come to the conclusion, like in the US, that basically the privacy framework here is not equivalent with the one in the European Union? There is some guidance from the EDPB in that regard as well. However, there are a lot of uncertainties what you have to do in individual cases. Of course, you can implement contractual measures. You can implement technical measures like encryption. You can define organizational measures in terms of that a party has to report if they have a request from a surveillance agency to the other party. But all that will generally not overcome access to personal data by public authorities. So everything you can do will never lead to a situation where a public authority, a US surveillance agency, would be impressed by that. And that's really the challenge, how you can solve that. What is important from a technical perspective is encryption. And you also find very interesting guidance from some authorities how encryption needs to be well set up and also managed with regard to the keys. So that is one very important from a technical perspective, I would say the most important thing that you would need to consider in the certain relation between 2 parties exchanging data. Well, and then I said there's light on the tunnel. On October 7, President Biden signed this executive order. And the new data privacy framework basically contains 3 key elements. First of all, it's the executive order itself, of course. Then the commercial data protection principles to which US organizations may self-certify. That is the same approach like the previous Privacy Shield. So that will be the same if this new agreement will come into force. And then also a very important part are the Department of Justice regulations. Oh, that was the wrong side. Because the two key criticism of the European Court of Justice in its Schrems II decision was that there was no appropriate redress mechanism under US law so far. So that was one very important thing why the ECJ said the Privacy Shield would not be valid anymore. And the other one was the very far-reaching rights of surveillance agency, and both topics have been addressed by this presidential order now. There is, in particular, a new data protection review court that will be established at the Department of Justice, and that is one very important part of this new data privacy framework. So if we look back into the slide that I presented in the beginning, the question is, how does that fit into the system of legal grounds under the GDPR for international data transfer? I would say that it is a mix between appropriate safeguards, like the previous Privacy Shield, so the self-certification process would probably belong into that column, and the new adequacy decision that is still to come from the European Commission would then, once it's in effect, belong into this first column. So actually a mix, but before we have this mix ready, the EU Commission needs to do their homework as well. On this side, you see once again the key bullet points about what contains this new framework. I already mentioned that EU individuals may seek redress from a multi-layer redress mechanism that should now be implemented as the already mentioned Independent Data Protection Review Court. That is one very important part of it, and as I said, the US intelligence agencies will also adopt procedures to ensure effective oversight of new privacy and civil liberty standards. That's it very briefly. The important question now is what is the timeline and what has to be done on the side of the European Commission. And what I can say is that this will take quite some time because the European Commission needs not only to involve the European Data Protection Board, which will now start to work on their position and on a legal report, how they see things, and if they believe that this new framework complies with the requirements of the European Court of Justice. But also the member states will have to do their homework. They have to submit their positions too. So if we take all that into account, I think before summer 2023, we will not see this new framework into force, maybe even longer. Depends, of course, very much on, well, how critical or not critical the positions in particular of the European Data Protection Board will be. Key question that everyone is asking, of course, is will the new data privacy framework be challenged again? The answer is very clear and didn't come as a surprise. It will, definitely. That was what everyone accepted. Max Schrems and his organization, they were only waiting for this executive order in order to check if they would see room for another court case that they will bring up, and everyone is very sure about that they will do so, and they already announced on their website that you can see here on the screenshot that they do not believe that this executive order complies with the requirements for international data transfer as set out in the Schrems II decision. So it's absolutely clear that they will take legal action against it. The only question is not only will that be successful or not, but also, of course, how long does the court proceedings take and how long it gives that time for the industry to rely on this additional legal ground for international data transfer. So challenging times ahead. A lot of legal uncertainty remains. And the most important advice that I would give at the end is really always keep in mind that the GDPR has a risk-based approach. And of course, it's a difference if you are Google or if you're a life science company. That's really one important advice, and I think the mistake that many make, and also the mistake in the view of many data protection authorities in Europe, is that they have the same view on completely different kind of industries and different data protection in different contexts. That does not, of course, not mean that life science companies can take it easy. It's the opposite. You have to take it serious. But the risk-based approach, I think, helps in many ways to find a practical approach. In some cases, also find a lean approach and not overdo it, depending very much on the individual context of the exchange of data, not only in the international context. Thank you. Questions, please, if there are any. From the remote audience, Amanda?
I don't see any. Tracy, do you see me? Okay.
Okay.
Nope. Yeah.
Okay, good. Thank you. Then I hand over again, no, not again, to Paul.